Now, Section 3 of the Hindu Minority and Guardianship Act says that the provisions of this act shall be in supplement to and in addition to and save not as hereby expressly provided in derogation to the Guardian and Wards Act 1890. So the immediate fallback is on the Guardian and Wards Act 1890. Now, what is the Guardian and Wards Act 1890? Now, the Guardian and Wards Act 1890 is a colonial piece of legislation which was made by the Britishers for the purposes of administration of their own purposes, and it is a law relating to consolidating the and amending the law relating to Guardian and Wards. So, Guardian and Wards Act 1890 is a secular law which is applicable to all communities. So, unhappily or sadly, if anybody wants to obtain any court order pertaining to guardianship or custody, one has to file a petition under the Guardian and Wards Act, because the Guardian and Wards Act is the only statutory law under which uh, the petition can be filed. So, if you have to file a petition, so let us say if there is a dispute on custody between parents or parents, grandparents, or relatives, then you have to file your petition under the Hindu Minority and Guardianship Act, read with the Guardian and Wards Act. So your right flows from the personal law, but the right to move court comes from the Guardian and Wards Act. So, to whom does this act apply? It applies to all persons who are Hindus by religion and any person who's a, as you know, Buddhist, Sikh, Jain, or Hindu by religion. Now, who is a guardian? Guardian means a person having the care of a person, of a minor and his property, and includes what? One, a natural guardian, a guardian appointed by the will of the father or the mother, and a guardian appointed by the court. So, a guardian, that is to say, a guardian appointed by the court, is obviously there when the guardian, uh, a natural guardian, is sought to be displaced. So, the natural guardian, the father or the mother, can be displaced for appointment by a guardian to be appointed by the court if the guardian, natural guardian, the father or the mother, is unfit to be the guardian of the minor. Now, who under Section 6 of the Hindu Minority and Guardianship Act, the principal provision is laid down. It says, Section 6 says, the natural guardian of a Hindu shall be the father and after him the mother. Now, this distinction before or after in Gita Hariharan's case has been watered down to say that they are both equal. After or before doesn't matter. Now, so they are both natural guardians, and then it says further uh, that in the case of a minor or an unmarried boy or a girl, the guardian is the father and after him the mother, provided that the custody of a minor who has not attained the age of 5 years shall ordinarily be with the mother, and and in the case of an illegitimate boy or a girl, unmarried girl, the mother, and after him her the father. So principally, what is the provision saying? It says a boy less than five, a boy or a girl less than 5 years of age, custody of the mother, custody shall be with the mother. Now the word is ordinarily. So ordinarily should not be mean that it is a vested right. It means that it will depend on other considerations laid down, and I will come to this in a moment from now to explain what does ordinarily mean. So after Section 6 is the proviso which says that no person shall be entitled to be the natural guardian of a minor unless his natural guardian has ceased to be a Hindu, has completely renounced the world. So these are two exceptions. Then the powers of the natural guardian is under Section 8, and the court word is referred to as the Guardian and Wards Act court. Then we come to Section 13. Now, Section 13 is the provision which principally goes to say that in the appointment or declaration of any person as a guardian, of a Hindu minor by a court, the welfare of the minor shall be the paramount consideration. It further says that no person shall be entitled to the guardianship of the by virtue of the provision of this act or by any other law relating to guardianship among Hindus if the court is of the opinion that his or her guardianship will not be for the welfare of the minor. So, under section 13, it is very clearly said that your right as a natural guardian to guardianship and custody will be only on the parameter of the welfare of the child. So now going back to the word ordinarily in section 6 regarding custody of a minor less than 5 years of age. Now, if the court comes to the conclusion that the welfare of the minor is at stake and custody of a child less than 5 years of age should not be with the mother, then the court can displace the custody. Now, this thinking was not there previously, but it has come in two recent judgments of the Supreme Court. One is, I have circulated material to you, so you will find the citations in the material. But for the purposes of just referring to these judgments, I am going to very briefly refer to these two judgments. Now, one is Lahari Sakhamuri and the other is Vasuda Sethi. Now, before I go to what exactly is the welfare of the child, I must update you on one very important factor, and that is that the rights of the child have come in by virtue of the fact that India has signed the United Nations Convention on the Rights of the Child. Now, the UNCRC is an international convention which contains provisions for the welfare of the child. You can look it up online. So, all parties who sign this treaty have to ensure that they adapt to the principles relating to the welfare of the child. So, India acceded to this convention or signed this convention on 11th of December 1992. But it took India quite some time to add on the beneficial provisions of the convention to the Indian statute book. Now, under this convention, a child is a person who has a right to life, who has a right to a nationality, who has a right to a parents, both parents, who has a right to a home, and so on and so forth. Now, based on this charter of rights for the welfare of the child, India was obliged to make beneficial laws or provisions in domestic laws to give force to the convention. So, just for your understanding, whenever India signs an international convention or a treaty, then India per force is obliged to follow the principles in the convention by making changes in domestic laws. So we had the Juvenile Justice, Care and Protection of Children Act of 2000. We amended it in 2010. Then we again amended it in 2015. And the idea of amending it was that we wanted to incorporate the provisions of the UNCRC. Now, all the benefits accruing to the child under the UNCRC were incorporated in the JJ Act, and the definition of the welfare of the child or the best interest of the child was defined in section 2, subsection 9 of the Juvenile Justice, Care and Protection of Children Act 2015, for short, JJ Act. So JJ Act section 2, subsection 9 defines best interest of the child. It says, best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So once this definition of subsection 2, subsection 9 was coined, then the Supreme Court in Lahari Sakhamuri a child removal case in which a mother had removed children from the US. This decision was rendered by the Supreme Court in 2019. Now, in paragraph 43, the Supreme Court says the expression best interest of the child, which is always kept to be of paramount consideration, is indeed wide in its connotation, and it cannot mean or remain the love and care of the primary caregiver, i.e., the mother of the infant of the child who is only a few years old. So, this is where it says very clearly that it is not a vested right. And they further say the definition of best interest of child as envisaged in 2(9) of the JJ Act means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, emotional and natural development. So very clearly they said if a child less than 5 years of age is it is not in the interest of the child to have the custody, then the custody can be displaced. Now this thought perception went on further in the case of Vasudha Sethi versus Kiran Bhaskar. This case emerges from the Punjab and Haryana High Court. I was an amicus to assist the court in this matter. The mother had removed the child from the US for medical treatment and she refused to go back. The High Court ordered her to go back. She challenged the decision in the Supreme Court. And the Supreme Court, reiterating the finding of the High Court, said that when a court decides that it is in the best interest of the minor to remain in the custody of one of the parents, the rights of the other parents are bound to be affected. As provided in Clause A of Section 6, which I just read to you, of the 56 Act, in the case of a boy or a minor girl, the natural father, but ordinarily the custody of the mother who has not completed the age of 5 years shall be with the mother. They say further, on a conjoint reading of Section 1 of subsection 13, subsection 1 of 13, which I just read to you, read with Section 6A of the 56 Act, it is if it is found that the welfare of a minor whose age is more than 5 years requires that his custody should be with the mother, the court is bound to do so. So it says, even after 5 years of age, if the welfare requires the custody with the mother, it should be so. But they also say, in the same way, if interest of the minor, which is the paramount consideration, requires that the custody of a minor child should not be with the mother, the court will be justified in disturbing the custody of the mother, even if the age of the minor is less than 5 years old. So the Supreme Court is very clearly saying that age is just a number. There is no vested right. Custody can move here and there depending on the situation, and therefore there is no vested right with either of the parents. So this is the first thing which ought to be very clear to you. Now, another thing which I want to break up here and leave it at that is that when we talk of the natural guardianship of a minor under the HMGA, it is said here that the custody of a child shall be less than 5 years old, shall be ordinarily with the mother. Now, there is a thought perception that because the custody is with the mother, therefore the residence of the mother is the residence of the child. Now, what is the significance of this terminology? We will understand when we go to the Guardian and Wards Act. Now, the Guardian and Wards Act of 1890 is a colonial piece of legislation, but be that as it may, we have to follow it. The Law Commission in its report number 257 of 2015, a brilliant report authored by Justice Shah, has recommended the Guardian and Wards Act to be amended. He has even given an amended provision, but nothing has happened. The report is still as it is. So, again, in the Guardian and Wards Act, we define the word court is defined, the word guardian is defined. Then, power of the court to appoint a guardian under Section 7. So it says, if the court is satisfied that it is for the welfare of the minor, that a guardian should be appointed. A guardian can be appointed and declared by the court. Now, Section 8 talks of who can be appointed a guardian. So, any person desirous of being the guardian, any relative of the guardian can be appointed. Now, with Section 7 and 8, you have to read Section 19. Section 19 says that if there is a natural guardian to be appointed by the guardian to be displaced, then Section 19 says that this can only be done when the father or the mother, in the opinion of the court, are unfit to be the guardian of the minor. So, if you are going to displace a natural guardian under Section 7 and 8, you have to, under Section 19, declare the natural guardian unfit. And the reason is obvious. Once there is a natural guardian, any other guardian cannot be appointed because the guardian's parent is there to look after him. Now, the jurisdictional aspect of Section 9 relates to where the petition for guardianship has to be filed. So, Section 9 says if the application is in respect of the guardianship of the person, of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. Now, the word ordinarily resides is the place where the minor's guardianship petition has to be filed. So, Section 9 decides where the guardianship petition is to be filed, and that is where the minor is living. And this minor ordinarily resides has been interpreted to mean where the guardian permanently and habitually resides, not the place where the guardian is removed forcibly by one parent, or the guardian or the child is present on the date of the filing of the petition. So, this will mean clearly that if a mother goes temporarily to some place, mother cannot say, I am temporarily residing here, my residence is the residence of the minor, and therefore Section 6 of the HMGA will decide jurisdiction. No, this is a perception which doesn't find favor. Section 9 of the Guardian and Wards Act decides, and the place where the minor lives is the place where the guardianship petition should be filed. Now, the next provision is Section 12. Section 12 is the power of the court to make orders for the protection of the minor and the protection of the minor. Now, there is a new thought perception, there is a change in thinking that because of the UNCRC, children should not be given to one parent. Children should be shared or equally divided between both parents, so that they have equal quality time with the parents. Because a child needs both the father and the mother. And in Vasudha Sethi, the Supreme Court is saying that whenever the court disturbs the custody of one parent, unless there are compelling reasons, the court will normally provide for visitation rights of the other parent. The reason is that the child needs the company of both parents. The order for visitation rights are essentially passed for the welfare of the minors and for the protection of their right of having the company of both parents. Such orders are not passed only for protecting the rights of parents. So it is said that it is not the rights of parents but the right of the child which is to be protected. We cannot accept the submission that while applying the welfare principle, the rights of the mother or the father need to be protected. The consideration of the well-being and the welfare of the child must get precedence over the individual or personal rights of the parents. So, a child custody petition is not a divorce petition to decide who is a better parent. It is the right of the child to have the love of both parents. That is what matters. So, it is the rights of the child and not the rights of the parents which have actually to be determined when this issue is cropping up. So, whenever you have a petition in which a parent is saying, I want custody, I want exclusive control, Now, it is in this predicament, Section 12, whereby interim orders or orders during the pendency of the petition have to be passed, say that the court may direct the person, if any, having the custody of the minor, shall produce him or cause him to be produced, and may make such order for the temporary custody and protection of the person of the property of the minor as it thinks proper. Now, I have always urged that the word such order for temporary custody does not mean that the court should give exclusive custody to one parent. It means such order can mean a order of shared custody, a order of joint parenting. So this word such order is a flexible interpretation, and I will come to it when I read the Family Courts Act, to say that a family court is free to adapt to the interpretation of the word by impressing upon the fact that a child's singular custody with one parent is not a good idea. It can pass a temporary custody order or a temporary arrangement sharing the child between both parents. Now, this is led in life. This is also to be read with Section 17, because Section 17 again talks of matters to be considered by the court in appointing a guardian. It says, in appointing or declaring a guardian of a minor, the court shall, subject to the provision of the guardian, and by what consistently has been the law for the timing in force, and the minor is subject, appears to be in the circumstances for the welfare of the child. So again, Section 17 says, whatever you do, welfare of the child. So if you read 12 and 17 together, such order can mean joint custody, joint parenting. So if a parent says, I am a better parent, I have superior rights, that is not a valuable consideration. The consideration is, what does the child need? You may be a bad husband and a very bad wife, or a very bad wife or a good husband. So your rights as husband and wife don't matter. If you are good parents, you may be at war with each other. You deserve the child. The child needs both of you. So in this circumstance, the welfare of the minor is the paramount consideration. Now, Section 17, subsection 3 also says, if the minor is old enough to form an intelligent preference, the court may, not shall, consider the preference. So again, the minor's issue consideration, the minor can be spoken to if the minor is able to express himself. Now, Section 25 talks of the return of a guardian, return of a custody of a child if a child is taken away. Section 26 says that the child shall not be removed out of the jurisdiction of the court. So this makes the reading of two of these acts complete. But then we come into the next act which is relevant for the purposes, and that is the Family Courts Act of 1984. Now, conventionally and typically, in most places in India, family court petitions were dealt with by the district court, because under the Hindu Marriage Act, the district judge or the appointee of the district judge shall be the judge to decide the divorce matter. Under the Guardian and Wards Act, the powers were to be delegated. So the guardian judge used to be a civil judge. But under the Family Courts Act, it is provided that this is an act to provide for the establishment of family courts with a view to promote conciliation in and secure speedy settlement of disputes relating to marriage and family affairs and for matters connected therewith. So under the Family Courts Act 1984, you have to create a family court. The act requires that wherever there is a population of more than 10 lakhs, you can have a family court, but this process requires notification. So unless and until there is a family court notified, the court may not really come into existence. Now, then the provision relating to jurisdiction. Now, Section 7 of the Family Courts Act says that, subject to other provisions, the family court shall be the only court to exercise jurisdiction and the jurisdiction of the district court will be excluded in matters relating to marriage, validity of marriage, then property, then injunction, then legitimacy. And what is important here is a suit or proceeding in relation to guardianship of the person or the custody or access of the minor. So anything to do with guardianship, custody, access of the minor shall go to the family court. And section 8 says that if there is a family court exercising jurisdiction under section 7, then no district court or civil court shall exercise jurisdiction in such matters. Now, district court will also mean high court. Now, for your knowledge, uh, the high courts in Delhi, Bombay, and Calcutta have original jurisdiction. Original jurisdiction means jurisdiction to entertain suits or original cases. Bombay, Delhi, and Calcutta are old chartered courts established by the British with original jurisdiction. Other states do not have original jurisdiction with the high courts. So, if Delhi High Court is entertaining a suit, even the jurisdiction of the Delhi High Court will be barred in matters concerning the Family Courts Act. Then we come to duty of the family court to make settlement. Then we come to section 10, procedure. Now, section 10 of the Family Courts Act says that the procedure laid down in the Civil Procedure Code, that is the statutory and procedural provisions relating to civil procedure, shall apply to the family courts. But section 10, subsection 3 says that nothing in this subsection shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter of the suit or proceeding, or at the truth of the facts alleged by one party and denied by the other. So, even though the provision says that civil procedure code will apply, but there is flexibility, there is latitude, there is discretion with the family court to devise an independent procedure. So the family court can say pleadings are complete, parties have substantially put across their points, the issues have been framed. Now the court says, I will arrive at my own way of dealing with it procedurally. So this liberty is granted to the family court in doing what can be wanted. Now I read this with the provisions regarding shared custody in section 12 of the Guardian Wards Act and section 6 of the Hindu Minority and Guardianship Act. So procedurally, if the court thinks that in an application for temporary custody, the court procedurally should decide a shared or a joint parenting plan, then the court has the power to do so. And this flexibility is given under section 10 of the Family Courts Act. Now, then we all come to section 14. Section 14 says Application of Evidence Act. So it principally says the Evidence Act 1872 will apply. Now, it also says the family court may receive as evidence any report, statement, document, information, or matter that may, in its opinion, assist with it to deal effectually with a dispute, whether or not same that would be otherwise relevant or admissible under the Indian Evidence Act 1872. So, ordinarily speaking, in a civil court or a criminal court, Evidence Act compliance is necessary, but family court has the discretion to take any document, report, or any information or evidence if the family court thinks it is necessary to decide the dispute. So this is again latitude shown to the family court to play with the provisions if the matter can be settled one way or the other. Now, section 12 talks of appointment of medical and other experts to assist the court, and section 13 talks of right of legal representation. Now, ordinarily, like a labor court under the Industrial Disputes Act, appearance of lawyers is not permitted. But Section 13 says, notwithstanding anything contained in any law, no party shall be entitled in a suit or proceeding before a family court to be, as a right, be represented by a legal practitioner. Now, this is to prevent the matters from being complicated, but actually speaking, without the assistance of lawyers, the matters cannot be resolved. So, therefore, what is done is that a lawyer moves an application that I should be allowed to appear before the family court. If one lawyer is already appearing or one lawyer is already applied for permission, then the court permits both lawyers. And because the matters get so technical that having the lawyers whom I would think are a necessary evil have to be brought in these circumstances. So this is as far as this issue is concerned. Now, just to run you through some judgments to give you clarity of concepts. Now, the issue of jurisdiction, what is the jurisdiction of a family court? What is the nature of powers? This is very well defined in the celebrated judgment of Ruchi Maju. Now, Ruchi Maju is a judgment of 2011. It says very briefly and broadly in paras 60, 61, and 62 that the jurisdiction of a family court is covered by procedurally by Guardian and Wards Act. It says in cases arising out of proceedings under the Guardian and Wards Act, jurisdiction of the court is determined by whether the minor resides within the area. So it says there is a difference between the jurisdiction facts in a writ court on one hand and in a court under the Guardian and Wards Act. Now, what is the writ court power? Now, because we do not recognize interparental child removal as a wrong or an offense, which is otherwise defined or regulated by the Hague Convention on Civil Aspects of International Child Abduction 1980. Therefore, what happens when a child is removed from a foreign country and brought to India? The aggrieved parent coming from the foreign country moves the writ court under Article 226 of the Constitution. Under Article 226, there is a prerogative of the superior courts to issue writs. Writs are orders issued as a command by the High Court, and one of the 6 writs is a habeas corpus. So if a child is in wrongful confinement in the one custody of one parent, violating the rights of the other, then for the welfare of the child, the court, High Court, as parents portray, can exercise powers even if there is no jurisdiction with the court. So this is what is being said here, that the power of the guardian judge is circumscribed and limited, but the writ court is big. So it says, having said that, we must state that it is clear that no matter a court is exercising powers under the Guardian and Wards Act, it can choose to hold a summary inquiry into the matter and pass orders if otherwise competent to entertain a petition for the custody manner under Section 9(1) of the Act. So 9(1) is jurisdiction. So jurisdiction means if the minor resides within a jurisdiction, the family court can exercise jurisdiction and pass a detailed or a summary order by a procedure. But then in para 62, they say it does not require much persuasion for us to hold that such issue, whether the court should hold a summary or a detailed inquiry, would arise only if the court finds that it has jurisdiction to entertain the matter. If the answer to the question of touching the jurisdiction is in the negative, the logical result has to be an order of dismissal of the proceedings or return of the application for presentation before the court competent to enter the same. So if the child doesn't live in the jurisdiction of the guardian judge, then no order. A court that has no jurisdiction to entertain a petition for custody cannot pass any order or issue any direction for the return of the child to the country from where the child is removed, even if such order is found to be in violation of the order of the court of the country. Party has to seek redressal by any other legal remedy. So this clears the wind on the jurisdictional aspect. And as I told you, The determining factor is Section 9 of the Guardian and Wards Act and not Section 6. Now, another very important judgment which has come about in 2021 is what is the power of the family court or the guardian judge to deal with the Guardian and Wards Act petition for custody. Now, it's a very interesting matter. I argued it in the Supreme Court. It is reported as Aman Lohia versus Kiran Lohia. It's a decision of 2021. Now, this was a case where an Indian couple were daggers drawn on the issue of custody of a child about 3 years of age. On a guardianship petition being filed in Delhi and no order being passed here or there, the father took the unfortunate step of going to Dubai via Nepal and converting to Muslim religion. The mother went in a habeas corpus petition. The father did not comply. He was held guilty of contempt and of kidnapping. The CBI team was asked to bring him back. The matter reached the Supreme Court. The custody issue was challenged in the appeal also. When the father ran away, the mother moved an application in the family court for being transposed. That is, she wanted that she should become the petitioner from the respondent, and the father should be made the respondent. The family court allowed that application and on the same day granted custody to the mother. The father challenged this order in the High Court. When the matter regarding all cases was challenged in Supreme Court, the order of the family court challenged in the High Court was also taken up in Supreme Court. Supreme Court transferred the matter to the Supreme Court, and Justice Khanwilkar, Gawai, and Justice Murari heard this issue of the guardianship case exclusively. Now, I argued the matter in Supreme Court, and I urged that the substantive procedure in the Guardian and Wards Act of a petition, a reply, a rejoinder, pleadings, and necessary evidence has to be there before the matter can be resolved by the court one way or the other. The guardian judge is not a constitutional court or a writ court that it exercises high court powers and it can transpose on one day, same day grant procedure, same day grant custody. So the argument of the other side was that the guardian judge can devise his own procedure under the Family Courts Act, an act to take any document and evidence. Now, my argument was that unless and until there are cogent pleadings, there is substantive evidence, it cannot be done so. And I said that if such liberty is granted to the family court, then it will play havoc. Now, the Supreme Court in this petition has laid down a concrete formula of how these issues, how the procedure is to be gone by. They have said that there has to be a petition, there have to be pleadings, there has to be evidence, and then the court can devise its own procedure. So the Supreme Court set aside the matter, the order of the family judge, and remanded the matter back to the family court. It was a very tough case because the man had been convicted of criminal contempt, and the other side's argument was that he's a criminal. So I said he's not a criminal. He has violated the law, which is unjustified, which is wrong. But he's a father, so his rights have to be decided. So agreeing with my contention, the matter has been remanded and is now pending in the family court. Now, another judgment which I want to share with you is the judgment in Ashish Ranjan versus Anupma Tandon 2010 decision, followed in Perry Consagra's case by the Supreme Court. Now, in this judgment, in para 19, they say, it is well settled in a proposition that while determining the question as to which parent has the care or custody of the child, paramount consideration will be the welfare and not the rights of the parents under the statute. So while considering the welfare, moral and ethical welfare of the child must also weigh. Child cannot be treated as a property or a commodity, and therefore such issues have to be handled by the court with care and caution. They say, though the provisions of special statutes govern the rights of parents may be taken into consideration, there is nothing that stands in the way of the court to exercise its participatory jurisdiction arising in such cases. Statutory provisions dealing with the custody of the child under any personal law cannot and must not supersede the paramount consideration as to what is the welfare of the child, and no statute on the subject can ignore, eschew, or obliterate the factor that is the welfare of the minor. So it is very important that the rights of the child must be considered, and the court says that a child of small age may not be able to learn family values, importance of pending or interpersonal relationships if he gets inadequate opportunity for social interaction. It is necessary for a child that he should be in regular contact of the non-custodial parent also. So shared parenting, joint custody are issues which are very important in this circumstance. And on the aspect of jurisdiction, Tejaswini God, a 2019 decision is very important. It says a lot of things, but very meaningfully. It very clearly says that in cases under the Guardian and Wards Act, jurisdiction of the court is determined by the fact where the minor ordinally resides in the area of the court having jurisdiction. So this is broadly the view. Now there are perceptions developing on shared parenting and alienation. Now, what is parental alienation? Now, when one child is in the custody of one parent for a very long time, the child gets polarized, he gets alienated, he starts treating the non custodial parent with animosity, with anger, and this segregation is called parental alienation. It has been recognized as a serious disorder by the WHO. And this is identified in Vivek Singh versus Rumani Singh by Justice Sikri in the Supreme Court. Now, to deal with this, we have now come up with judgments. There is a judgment of the Karnataka High Court in Savita Sitaram. There is a judgment of the Bombay High Court in Tushar Obale. There is the judgment of the Delhi High Court in NS. Navtej Singh versus uh, Navtej Singh versus Jasmeet Kaur. JK versus NS. Now, these three judgments talk of shared parenting, joint custody, etc. Now, there are exceptions when joint parenting should not be granted, and that is where there is violence, harm, or abuse. But otherwise, there is a very strong urge that the uh, child should be shared by both parents. There should be a child-centered jurisprudence. Child should be heard wherever possible, and custody and guardianship should be in a shared proportion. So this is very, in a very short time, a wide circumsphere of what is contained in the law. So uh, I think we should have some time for you to have your doubts cleared. So if anybody of you who has a doubt or a question, please feel free to put your question in the chat box or directly to me, and I'll be very happy to address it right away. We can start with your question, ma'am, first. I'm
No,
sure you.
actually, sir, that was a wonderful lecture, and I was reading Vivek Singh versus Romani Singh and the idea of parental alienation syndrome a few days back. The only issue I have with that idea is that once the child has been, a part of that syndrome, or the child has been affected by that syndrome, how do you think shared parenting would work? Because the child for a lot of years has been fed that one particular parent is the negative one, or because of one particular parent so and so marriage did not work out. So when the court later orders any sort of shared parenting order, how do you think it will work out for the child, because the child is already infested with that idea against one parent? So in the
See,
practicality aspect, how will it work out?
the answer is in Vivek Singh versus Rumani Singh itself, because the court refused to take a call on the custodial rights. And the court says, unless the other parent has also got a level playing field, we are not going to take a call. So, what is the way out? The way out is that the access, the custody which was denied to the non custodial parent should be restored. And it should be made free, and it should be made easily available to the other parent. You should let the child get over that inhibition, that reservation, and that fear. And the only way you can do it is by contact. See, initially the child will be hostile, but
Hmm.
then you have to have contact of the child with the other parent. Now, in the COVID pandemic, a lot of this has happened because
Hmm.
whoever had the custody said, I am not going to let the other parent anywhere near the child. There is a
Yeah.
total hostility. So the child starts thinking, this is the end, this is the only parent. So the only way out is you have to let the child alone with the other parent. There was a case in Delhi where a father was given access with three of his children for 1 hour on the computer every day by the court with the door open, not locked, and the mother not coming anywhere near the computer. And it slowly
Hmm.
developed. Now I remember doing a case where a boy, this was a couple from your home state. Perfect marriage. Both were well, well in doing well in life. They lived in England for a couple of years. Did well. The man was a hi-fi computer programmer, so they used to travel a lot. The child was born in England, but they chose Indian citizenship. They had a daughter with Indian citizenship. The father had a British passport. The mother had an Indian passport. So they fell apart. So they started living together apart. So she was living in Sonipat with her parents. He was living in Jeend. So they got separated. He was in the US. He got stuck in the pandemic. So when he came back, he tried to find his wife, and he called her up, and she says, I'm in the US. I'm in UK. So he filed a petition in the British court, and he got a order of access to his children for 1 hour every Monday, Wednesday, Friday. Now, whenever he would talk to his daughter, it was all well. But whenever he would try to talk to his son, he found he was asleep. And one day he noticed a fan. So he realized that something was wrong. So he landed up in jail, in Sonipat. So there he found his son was there in Sonipat with the maternal grandparents. So there was a tiff and they fought. So we filed a habeas corpus. So the court said that this is weird. You are saying the mother was told, you are saying the child is in England, but the child is in Sonipat. So
Hmm.
he got access to his son and to his daughter. Now, whenever he would talk to his daughter, that 11-year-old girl, you'd be surprised the kind of language she would be using as a father. She was polarized. So that was the effect of the poisoning of the mind of the child. Now, slowly, slowly, he started talking and he brought around the daughter. So the only way is contact. The more you deepen the contact, the wider the rift. The more you fill up the gap, the will go away. But it can develop into disaster. I remember Jatinder Arora versus Sukriti Arora, two children separated. The, the either child didn't want to see each other, either parent didn't want to see each other. One child with mother in England, one child with father in Delhi. Then there is another reported decision of the Supreme Court where the same thing happened. See, delay in decisions worsens the issue. The only way to resolve this is one, contact, two, counseling of the child,
Correct.
three, evaluation by a medical expert, provide medical treatment. Let the child go to a psychologist or a counselor and speak. Let the child be explained, taught. So these are professional means. We haven't developed a lot of it as yet, but we have
Hmm.
problems because in the pandemic they have worsened. So that is the way out.
You correctly said, and also I think it's extremely important that Supreme Court does not delay in such cases, because once the polarized, thinking in the particular child goes on for say 8 years, 10 years, then it gets very difficult for that
See,
to go away.
I remember this matter from Bombay High Court, where the father had got, I think, 2 or 3 children from the US 2 3 years for 2 3 years. The mother filed a petition in Delhi, Bombay High Court. She lost. She went to Supreme Court. She lost. The Supreme Court, she said they are alienated. The Supreme Court called for the children and they spoke to the children online. The children said, we don't want to see our mother. And that was the end of the habeas corpus. Why? There was too much delay. The gap was too wide. So this is a problem which the court has to look at it itself, that any delay in decision is fatal. Well, what do? We take, the problem as I look at it is, first the family court opens the whole thing. It decides, then it goes to High Court, and sorry, the High Court opens the whole thing. Then it goes to Supreme Court, they open the whole thing. It takes too long. There has to
Correct.
be a fast decision-making process. That doesn't happen. And when that doesn't happen, it's bad. That's it. That's the sad part.
So, aren't the family courts looking at this underlying psychoanalysis of parental alienation syndrome?
The problem, see, as far as Bombay, Delhi, Goa, Bangalore are concerned, they are pretty far ahead. 88, the Family Courts Act was made in 84. Family courts came into existence. They are dealing with this issue. Bombay has come up with a unique experiment, a unique phenomenon they put into practice. They have a point. They have the family judge sitting in Bandra has 15 family court judges. So the principal judge has made a panel of 25 CILs, child independent lawyer. So there is a
Okay.
lawyer in panel to act for the child who will represent the child and try to come with a solution straight away. But in Punjab and Haryana, we have come up with courts in 2012, 2015. These concepts are so alien.
Hmm.
So
True.
we will take time to develop a team of psychologists. Everything is in there in the act. Amicus, counselors, experts, mediators. But we have to develop the infrastructure. You go to Delhi, every family court building is separate from the civil court. The judge is sitting in his own building with a counselor, with an expert. The parties are appearing in person. We have yet to take up that speed in the north.
Hmm.
Though in Pune, Bombay, Calcutta, I travel all over. Some courts think are very advanced. So we are a huge country. These things are new to us, and
True.
this is a problem of a minority. Look at the underprivileged who have no 2 square meals a day. Where can you talk of parental alienation in those
Yes.
circumstances? Where survival is itself a question. So
Absolutely.
there are different issues in social setup, but that be so. We cannot say we are alien to the problem. We have to address it
Hmm.
because we have a 30 million NRI migratory community. They bring all these concepts from abroad. How do we deal with them? We have to take cater to them. If you bring a child from the US or England and you park the child here for 2 or 3 years, the child doesn't want to see his father. What do? Contact or go back. These and because we haven't signed the convention on abduction, we do keep doing a flip flop. Sometimes Supreme Court says send back, sometimes Supreme Court says we'll decide. So we keep moving up and down.
Yes.
Your This is your 3 year batch or 5 year batch?
This is 5 year batch. So,
Should have
any
questions.
questions from the batch? Please let's be a little interactive.
Maybe they see you in person only, then they ask questions.
Yes, Roshni.
Thank you for the wonderful session. I think it was very insightful. I had a question. So, we
Yeah.
talked about counseling the child and medical treatment and the psychoanalysis part of it. So, does
Yeah.
the legislation itself provide any such provision for counseling or any sort of health medical treatment for the child, or is it something that is done by the, the courts or the NGOs who are there who work
See,
for such
under
institutions?
Section 12 of the Family Courts Act, it is said in every suit or proceeding, it shall be open to the family court to secure the services of a medical expert or such person, whether related to the parties or not, including a person professionally qualified in engaging in promoting the welfare as the court may think fit for the purpose of assisting the family court in discharging the functions imposed by the act. So the family court has got complete freedom to go to a psychiatrist, a psychologist, a mediator, a family member, extended family. for help. So it's not something which is not provided for, it is provided for. But how far is the actual implementation of this remedy effective? That is what is to be seen. Now, with our huge numbers and the lack of experts, if you travel down to districts or smaller places, all this infrastructure may be missing. It may be existing in metropolitan cities. So the facility is there. It is a enlightened judge who has to put it into motion.
All right, thank you, sir.
Any other questions?
No, ma'am, no questions. Thank you.
Okay, so we meet at 11 now.
Yes, sir.
Okay,
And thank you so much, sir, for your
no, no,
valuable insights.
we'll keep the thank yous for the end.
All right. Thank you,
Okay,
sir. We'll start with the next session at 11.
okay, all the best. Thanks a lot. Bye.
Thank you so much, sir. Bye bye.